Well, good afternoon. It is 2 o'clock, so we're going to go ahead and get started. Thank you for joining us for today's webinar on succession planning, wills, and trusts. I'm Sarah Miller. I'm the Vice President of Marketing and Strategic Communications at the Small Business Association of Michigan, and I'm pleased to introduce to you Jennifer Long, an associate at Bodman PLC. She is a member of the High Net Worth Tax and Aviation Law and Finance Practice Groups. Ms. Long represents individual clients on estate planning and on gift and income tax matters. She also advises individual clients on corporate and transactional matters in connection with their closely held businesses. Ms. Long advises clients on federal tax implications associated with aircraft ownership and use and aircraft acquisitions. She has experience advising business aircraft owners on reorganizing ownership and entity structures to maintain and centralize control and generate tax savings and efficiencies for gift tax planning. Bodman PLC is an SBAM partner, and they staff our legal hotline that's available free of charge to premium and VIP members. If you have any questions throughout this presentation, feel free to email them to me or to Ms. Long. Her email will be made available at the end of the presentation, and my email is sarah.miller@sbam.org. We'll make sure to get them to her, and she will follow up with you after the webinar. So with that, I'm going to turn it over to Ms. Long for today's webinar. Thank you.
Okay, thank you. Good afternoon, everyone. My name is Jennifer Long, Jen, and we're going to be talking about estate tax planning and succession planning for your business. So I guess we'll jump right into it. I'm going to quiet my video here. Okay, so in this presentation, I will provide an overview of the estate planning process, updates to estate tax, information on revocable trusts, and succession planning for business owners. Estate plans allow you to maintain control of your assets and protects you if you become incapacitated. There are 3 common reasons people call for an estate plan. Life events like the birth of a child will cause people to start thinking about how much of their assets will go to their children, at what age will their children inherit those assets, and also choosing a legal guardian. Other life events that trigger estate planning needs are marriage, divorce, death, or disability. Upcoming surgery is another reason. While there are obviously many physical and emotional considerations as you prepare for surgery, don't forget about making sure your legal affairs are in order as well. Preparing your estate plan documents pre-surgery can help give you a peace of mind as you enter the hospital for your procedure. There is also international travel. Should anything happen to you during your trip, your loved ones would already be thrown into a difficult and emotional time. You can minimize the stress for them in such a situation by having your affairs in order before you go. In your will, you can designate who you would like to serve as your child's legal guardian. Without a will, you leave it to the court to decide pursuant to state law. An estate plan gives you the power to decide how you want to dispose of your assets. Again, without an estate plan, the court decides what happens to your assets according to state law. As we will discuss later, an estate plan also allows you to plan for the transfer of your business interest. Your basic estate plan will include a will, trust, financial power of attorney, and medical forms. A will is a legal document that communicates your final wishes. If your estate plan does not include a revocable trust, then your last will and testament will contain a detailed list of instructions as to how your property should be distributed after you die. If you have a revocable trust in your estate plan, then your last will and testament may be used as a safety net to catch assets that you did not transfer into your trust prior to your death and put them in your trust after your death. This type of will is referred to as a pour-over will and contains minimal instructions since your revocable trust is the main document that would govern your estate plan. A trust is an arrangement that allows a third party or trustee to hold assets on behalf of a beneficiary or beneficiaries. Trusts can be arranged in many ways and can specify exactly how and when the assets pass to the beneficiaries. A revocable trust is a trust where provisions can be altered or canceled depending on the creator of the trust, also known as the donor or the grantor. Revocable trusts contain a detailed set of instructions covering 3 important periods of your life. 1, what happens while you are alive and well? 2, what happens if you become mentally incapacitated? And 3, what happens after your death? In addition, assets held in the name of your revocable trust at the time of your death will avoid probate. In simple terms, probate is the legal process for distributing your property after you die. It's required when someone dies leaving a will, or even if they don't leave a will, because the property has no other way of passing to a living individual. A revocable trust doesn't require probate because the trust owns the assets and the trust hasn't died. It's a private contract between you as the grantor and the trust entity. Once your trust is created, you can begin to fund your revocable trust by assigning personal property to your trust. Most people need a will, but not everyone will need a revocable trust. Whether or not you need a revocable trust depends on many factors, including your age, your assets, and marital status. Even if you decide that you do need a trust, you should also make a will to name a personal representative, name guardians for minor children, and take care of any property that doesn't end up in your trust. A durable power of attorney is a financial power of attorney that allows you to delegate to the person of your choice the ability to manage assets that are titled in your individual name, including retirement plans and assets titled in joint names. The patient advocate designation allows you to designate a healthcare agent to make medical decisions for you for any reason that you are unable to make them. The living will gives guidelines for your physician and family to follow if you are terminally ill or are in a persistent vegetative state. The medical release authorization form, HIPAA, is a document that allows an appointed person or party to share specific health information with another person or group. With all this talk about estate planning, it's important that we discuss what an estate actually is. An estate is basically everything comprising the net worth of an individual, including all land, possessions, and other assets that the individual owns or has a controlling interest in. Probate assets are assets that are distributed by the court. Probate assets may pass by will or what we call intestate succession. Basically, when you die without making a will, and the court will distribute your property according to the laws of the state. A state court must authorize the transfer of probate assets, including assets owned individually, your share of assets owned through a specific type of joint ownership, tenants in common, life insurance, annuities, and retirement assets without a beneficiary designation also pass through probate. A beneficiary designation is the process of naming someone as the recipient of your proceeds. If you don't name a recipient, these proceeds will pass through probate. Additionally, life insurance, annuities, and retirement assets pass through probate if the estate is the named beneficiary or if the named beneficiary is deceased. Individuals like to avoid probate proceedings because they are an added cost, public, time-consuming, and delays administration of the estate and the ability of your heirs to receive your assets as you intend. Non-probate assets are assets that bypass the court process and go directly to your beneficiaries. These assets include certain types of jointly owned property, bank accounts, and real estate. Property held in a trust continues to be owned by the trust, and it is distributed pursuant to the terms of the trust. So that doesn't pass through probate as well. Note, a revocable trust becomes irrevocable at the grantor's death. An irrevocable trust cannot be changed or modified in any way. The trust becomes a separate taxpayer from the deceased, and an income tax return may be required for the trust. Property passing by valid beneficiary designation, other than the estate, pass to your designated beneficiaries. For example, life insurance and retirement accounts, your IRAs, your 401ks, where a beneficiary is named, do not pass through probate. Similar to beneficiary designations, for insurance and retirement accounts, payable on death accounts do not pass through probate. A payable on death account is an arrangement between a bank or credit union and the client that designates beneficiaries to receive all of the client's assets. When naming a beneficiary of a brokerage or investment account, the designation is usually called a transfer on death account. Those assets do not pass through probate as well. The term gross estate refers to the total dollar value of an individual's property and assets at the time of his or her death. Taxation of your gross estate depends on the type of asset you have and the amount of control you retain. Individually owned assets are considered controlled by you, so all of it will be subject to tax. If you hold an asset with your spouse, which is usually held jointly, 50% of the value of that asset is deemed to be owned by you. So 50% is included in your estate. This is not getting into community property state laws, however. Strings attached assets are assets that you transfer, but you still retain some type of control over it. For example, the right to revoke it. Assets in a revocable trust are considered a part of your estate because you can revoke the trust. This is different from an irrevocable trust as long as you are not the beneficiary or don't retain certain rights. With pay on death or transfer on death accounts, even though you directed those assets to someone specifically, it's still considered something you own. However, even if you die owning assets, you may not be taxed on them because the IRS does not tax a certain amount of each estate. For an individual dying in 2019, the IRS says that they will only be taxed on their estate on amounts that exceed 11.4 million. Amounts over the 11.4 per person will be taxed at 40%. There is a 11.4 million exception for amounts that you can gift tax-free as well. However, the exemption is unified, which means that the 11.4 represents the total amount that can be given away during your lifetime or at death, tax-free, either by a lifetime gift or transfers at your death. For example, if you gift $1 million during your lifetime, at your death, your total exemption amount is reduced by that 1 million. So now your exemption amount is 10.4 million. There is also a 11.4 million generation skipping transfer tax exemption, or GST exemption. The GST tax is imposed on transfers to grandchildren and more remote descendants that exceed the exemption limits to ensure taxes are paid at each generational level and that they are not avoided through the use of a trust. The tax is only due when a skipped person receives amounts in excess of the GST estate tax credit. The IRS also allows an individual to port the unused tax exemption of their deceased spouse. So if your deceased spouse did not use their exemption. Through portability, you can add their unused exemption to your exemption for a total of $22.8 million, which means that your estate will only be taxed on amounts that exceed $22.8 million. To get the portability, the estate tax return is filed when the first spouse dies, even if no estate tax is owed. The return is due 9 months after the death, with a 6-month extension allowed. If the personal representative does not file the return or misses the deadline, the surviving spouse loses the right to portability. The personal representative is just the person required to file the return on behalf of the deceased spouse. The IRS also allows an individual a gift tax annual exclusion amount of $15,000, which basically means that you can gift up to $15,000 a year without eating into your $11.4 million exemption. For married couples, they can combine their annual amounts and gift $30,000 a year to a person. If you do gift over the $15,000 exemption and don't use a portion of your $11.4 exemption to alleviate the tax, amounts exceeding $15,000 will be taxed. So for example, if you gift $10,000 in year 1, that $10,000 will not be taxed because it does not exceed the $15,000 gift tax annual exclusion. But in year 2, if you gift $100,000, you will either pay tax on the $85,000 that exceeds the $15,000 gift exclusion, or you can use $85,000 of your $11.4 million exemption to alleviate the tax. So if you die in year 3, the IRS will tax your estate on amounts that exceed your $11.4 million exemption, less the $85,000 of exemption you used in the prior year. Providing for your family is one of the most important aspects of estate planning. 2 options to provide for your spouse include leaving everything outright to your spouse, or you can transfer assets to a marital trust for the benefit of your spouse. The marital trust allows the grantor to retain some level of control versus giving the assets to your spouse outright. So if you have a spouse, you have flexibility in how you transfer assets to them. Either of those transfers produce a marital deduction. A marital deduction allows married couples to make unlimited transfers of property between them without incurring a tax, either during their lifetimes or after their deaths. To get the marital deduction, the marital trust has to be set up in a particular way and follow the requirements by the IRS to qualify. We call it a marital trust, but the actual name is Qualified Terminable Interest Property Trust. So again, transferring your assets outright gives the grantor, the trust creator, a marital deduction, which means that the grantor does not have to use up that 11.4 estate tax exemption. As such, an election can be made so that the estate tax exemption of the deceased spouse gets ported to the surviving spouse. For example, if the first spouse to die says all assets get distributed to a marital trust at my death for my spouse, then 0 exemption is used. 0 exemption is used because a marital deduction causes the transfer to your spouse to occur tax-free. As such, you're allowing your $11.4 million of estate tax exemption to go to portability for the benefit of your surviving spouse. You can also transfer assets and trust for your children. This makes certain that the money is protected if, for example, they are minors. You are able to provide for the well-being of your children by having a trust until your child or children are capable and ready to manage the funds on their own. Additionally, if you transfer assets for the educational and medical expenses of your family, Those amounts are not limited to the $15,000 annual gift exemption. If you have a taxable estate, which is an estate over $11.4 million, we suggest talking to an estate planning attorney. There are a lot of options available for planning for your estate. Once you prepare the documents to create your trust, you must fund the assets into the trust. Funding your revocable trust refers to taking assets that are titled in your name or in joint names with others and retitling them into the name of your trust. Some assets don't have official title documents, for example, furniture or artwork. You can assign those assets to your trust by signing a document called the assignment of property. The goal is to ensure that the property is governed by the terms of the trust agreement. If you don't fund your trust will have no effect on how your property is transferred after your death. Funding your trust allows you privacy with regards to yourself, your assets, and your beneficiaries. When a revocable trust is in place, a grantor's will usually states that the will be distributed in accordance with the terms of the trust. The will is a public document, however, and the probate process requires the disclosure of accounts, assets, and beneficiaries that would not be disclosed using a funded revocable trust. A revocable trust also avoids the expenses and delays of the probate court. The donor of the revocable trust continues to have exclusive control of the assets for as long as she or he is able or desires to be involved. When an event occurs that renders the donor unable to continue the management of the assets, the trust instrument provides specific directions to the trustee to intervene and control the assets. Using a revocable trust provides great flexibility. As individuals go through life, their needs and family circumstances change. Sometimes health issues or marital situations require a greater degree of flexibility. The revocable trust can be easily amended to address these changes rather than revising the entire trust instrument or re-executing your will. There are various reasons why people try to avoid probate. Probate pleadings are public documents. Probate generally requires the expense of an attorney. Probate can delay your heir's ability to use and enjoy your assets. Probate court inventory fee is charged based on the value of your probate estate. Your private business information may be exposed. Voting of stock and an election of directors can be delayed. There is also additional time and expense required to transfer stock from the individual to the estate, transfer stock from the individual to the individual's trust in a pour-over will situation, and transfer stock from trust to the beneficiaries. Most retirement plans, annuities, and life insurance policies let you decide what should become of your assets in the event of your death. They do this by asking you to designate beneficiaries. Oftentimes, a significant portion of your net worth is in assets with beneficiary designations, for example, life insurance and retirement accounts. Yet, they are rarely reviewed or updated only periodically. Not reviewing and updating your designations can create several issues. For example, assets may not be distributed according to your intentions. It may not get to the person you want them to, and when and how you want them to get to that person. Assets passing to minors will require probate and court involvement and appointment of a conservator. A conservator is just a guardian or protector that is appointed by a judge to manage the financial affairs of the minor. Not reviewing and updating your designations may cause probate proceedings to be necessary before funds can be dispersed to your beneficiaries. For example, if an estate is named as a beneficiary or if the beneficiary is deceased. You can fund your trust with life insurance proceeds or assets from a retirement account. For life insurance, do not change the ownership of any life insurance policies because this could cause an adverse tax result. You can name your revocable trust or your spouse as a primary beneficiary. That is a personal preference, however. But keep in mind, if you have a marital trust, naming your spouse as your primary beneficiary may cause too much of your assets to go outright to your spouse, which defeats the planning purpose of a marital trust, where you want to retain some level of control. For retirement accounts, do not change the ownership of any retirement account, because this could also cause an adverse tax result. Generally, it is better for income tax purposes to name your spouse first, then children, if they are adults, as your beneficiary. If you have minor children, you should name your revocable trust as a contingent beneficiary. It is important to make sure that your trust qualifies as a designated beneficiary. You can fund your trust with bank assets, retitle your checking, savings, and brokerage accounts into the name of your revocable trust. Joint assets with a spouse can remain as is, but you may want to add a pay-on-death designation naming your trust, for example, in a simultaneous death situation. Your bank can provide any necessary forms, including new signature cards. Retitle your certificates of deposits into the name of your revocable trust, unless held jointly. Note that most CDs cannot be retitled until they reach their maturity date without a substantial penalty being imposed. Therefore, we suggest that you wait until a CD reaches maturity before retitling. The financial institution holding the CD can provide any necessary forms. If you have a safe deposit box, consider adding one of your family members' names to it. This will avoid your personal representative or trustee from having any difficulty in opening the safe deposit box after your death. All business interests should be assigned to your revocable trust. Before transferring any business interests, have your attorney review your governing documents to ensure, one, that the transfer to your revocable trust is permissible, and two, the required formalities are followed. Governing documents include your operating agreement, shareholders agreement, articles of incorporation, or bylaws. You may also need to issue new stock certificates and cancel old ones. Also notify your accountant to update your tax forms. Make sure your personal property, furniture, furnishings, jewelry, is assigned to your revocable trust. You can use a simple assignment form to transfer your personal property. You may also leave a separate list designating who gets what of your personal property. You do not need to retitle your automobiles, however. This is because the Secretary of State has a procedure by which your next of kin should be able to retitle your automobiles at your death without having to open a probate estate. If you collect antique cars or have very expensive cars, you may want to consider retitling them into the name of your trust. If your home is owned jointly with your spouse, keep it that way. It provides the best asset protection from creditors and still avoids probate. Retitle other real estate into the name of your trust. In Michigan, real estate is assessed at 50% of its true cash value. Transfers to your revocable trust are exempt from transfer taxes and uncapping. Basically, Michigan provides a cap on future tax increases on residential real property, which was designed to limit the rate of increases in taxable values. This cap, however, would be removed and the property taxes would be uncapped whenever the property changed hands. In other words, whenever there was a change in ownership. Transferring real estate to your revocable trust does require recording a new deed and a completion of the property tax affidavit. If a residence is encumbered with a mortgage, federal law still permits you to transfer the residence to your revocable trust without triggering any due on sales clause. A due on sales clause is found in mortgages and trust deeds to prevent a seller from selling their property without paying the loan in full. When the home is transferred, you should also update your homeowner's policy to name the trust as an additional insured. Also note that a principal residence exemption, PRE, exempts a residence from the tax levied by a local school district for school operating purposes. With succession planning, you plan on transitioning out of your business on your terms, when you want, and how you want. There are many elements to transfer to business succession planning, but I will only focus on keeping your business within the family group. In other words, gifting to the next generation. You can transition ownership in your business by gifting or selling the ownership. You can make a gift of 100% of your business interest and give full control and ownership to the beneficiary who may sell or transfer the company as they please. In that case, your beneficiaries would assume the income tax liabilities associated with the company ownership. You can also gift your business interest to a trust. You, as a grantor or creator of the trust, can retain the income tax liabilities associated with the company ownership. The trustees of the trust would have control and ownership of the company. As grantor of the trust, however, you can decide on the trust terms, its beneficiaries, and distribution provisions. Typically, the gift option works best when the company interest is likely to appreciate, because all of that appreciated value is excluded from your estate when you pass away. If you would like to retain control, you can create two classes of ownership interest, voting and non-voting, and gift away the non-voting interest. In addition to retaining control, you also move the gifted assets out of your estate. Because you gift non-marketable minority interests, the gift is discounted for tax purposes. That results in a lower taxable gift and allows you to give more shares and use less of your estate tax exemption. The gifting option usually requires an appraisal of your interest to determine the gift value. A gift tax return will also need to be filed the following year to document the gift. No gift tax should be due, however, if you have sufficient gift tax exemption available, currently $11.4 million. One downside is that gifting an estate results in a basis carryover for income tax purposes, meaning that your current basis and your business interest would transfer to who you gifted the interest to. If a future sale for the company would occur, the potential income tax impact is a consideration. However, if you still own the business interest at the time of your death, then the basis of the interest will be stepped up or increased to its fair market value on your death when inherited by your beneficiaries. This helps minimize income tax on a future sale of the company. By gifting, you can give up that value in your estate, but you can retain the control to have a vote and you also are gifting at a reduced price. Many owners either lack an estate plan or have an inadequate plan that does not properly address their current situation, wishes, and disposition of their business upon their death. There are illiquidity of business interests and asset concerns with paying for a deceased owner's estate tax and buying out a deceased partner's interest. There are also concerns with the handling of the business interest once you have other owners in place. Some solutions are a buy-sell agreement or a life insurance trust. A buy-sell agreement puts a wrapper around what will be the plan when there is more than one person in the ownership. When you bring in the family and start transitioning into the next generation, you need a way to put a wrapper around how the interest will be transferred. When was the last time you updated your buy-sell agreement? Do you have a buy-sell agreement? Or are you thinking, what is a buy-sell agreement? Well, buy-sell agreements provide a mechanism for ensuring what happens to business interests. Buy-sell agreements are one of the most common and important succession planning tools in setting the parameters for an ownership transfer to your partners, heirs, or the next generation of leadership in your company. The agreement can be the cornerstone of solid estate planning, owner exit strategies, and business continuity plans. But oftentimes, they are filed away as soon as they are drafted and never revisited until it is too late, or they are never drafted in the first place. A buy-sell agreement can also eliminate or minimize future disputes and litigations upon a partner's death, disability, leaving the company, or other triggering events. Triggering events can include when an owner dies, becomes disabled, retires, or just wants to otherwise sell his interest during his life. The agreement may allow right of first refusal or require mandatory cross-purchase where the other party acquires the business owner's interest at a given price. A right of first refusal is a contractual right that gives the other party an option to purchase the business interest from the owner according to specified terms before the owner is entitled to enter into that transaction with a third party. For a right of first refusal, consider agreed upon value versus third-party market rate offers. Other shareholders do not want a bidding war. Such shareholders want to pay a lower agreed upon value as opposed to what a third party may be willing to pay in the market. For a cross purchase, all owners agree in advance to purchase a proportionate share of another owner's interest upon a triggering event. You can fund a cross purchase by having each owner purchase a life insurance policy on the life of each of the other owners and use death benefits to buy back the interest. Buy-sell agreements may require the company to redeem the stock or require that it be sold to a third party. Stock redemption by the company can be mandatory or optional. Consideration must be given to how the company will buy out the interest. The company could raise the needed funds by borrowing, selling business assets, or using cash reserves. But these approaches are inherently uncertain and may put a severe burden on the business operations. The company could be an owner and beneficiary of life insurance on each owner and use those death benefits to buy back the interest. Death benefits increase the overall value of the company. but obligations to buy the deceased owner's interest offsets this, so the valuation of the company may not be affected by the death benefit. The purchase price may be based on a formula, for example, 6 times net income, or appraisal at the time of the triggering event, if an agreed upon value cannot be reached. For an appraisal, you may agree that the CPA may make the final determination, or each party may select an appraiser and values can get averaged. For estate tax purposes, the IRS is not bound by the terms of a buy-sell agreement unless certain requirements are met. The buy-sell agreement is a bona fide business arrangement. The buy-sell agreement is not a means to transfer assets to the deceased family at less than fair market value, and the terms of the buy-sell agreement are comparable to similar arrangements in an arm's length transaction. As stated before, life insurance is often used to ensure cash is available to meet the obligations of the buy-sell agreement when an owner dies, particularly in an illiquidity situation. Absent an irrevocable life insurance trust, the insurance proceeds may be subject to estate taxes. The value of a business has a profound impact on many succession planning issues, gift and estate taxes, agreements among shareholders, and corporate finance strategies. Any decision about succession planning needs to incorporate an accurate plan for valuing the business. Then you will need to determine how to transfer out the company's assets. For example, do you transfer all or some of the business assets? You can establish new entities like an LLC, a limited liability company, for some assets with other owners. You could also sell your business or gift your interest, as previously mentioned, to retain control of your company. There are also income and estate tax issues to consider, but there are a lot of options available for income and estate tax planning with regards to your business interest. Also, business owners sometimes struggle with the issue of, if only one of my children is interested and/or involved in the business, how do I equalize my estate among all of my heirs? Basically, how do I make sure that my children are treated fairly and receive equal assets? The most common approach is to give other business or non-business estate assets to those not receiving any interest in the business, with the goal of equalizing the value received by everyone. How can a business owner control how and what assets are given in those situations? A business owner can use life insurance to provide those children who are not involved in the business with equitable treatment. If you transfer the business to multiple children and someone wants in and others want out, the life insurance can be used to buy people out when you don't have the money. So what if the plan does not work? What can be done if the owner gets disabled, dies earlier than expected, gets divorced, or there even is some type of substance abuse problem? The buy-sell arrangement can cover these situations. So what are the next steps? First, create your financial team. Your members should include an attorney, accountant, financial advisor, and insurance agent. Each should bring his or her unique skill set to provide a team approach and better client results. Then implement your plan. Your team should develop a customized plan with your review. Your team should each put their portion of the plan into place. Communication is key here. Your team should communicate with you and other team members in an effective manner. Finally, you need to monitor the plan in the future. The plan is never complete. It is a process. Your financial advisor must manage your investments. Your accountant must file the necessary returns and inform you of new developments. Your attorney should apprise you of changes in the law, and your insurance agent should advise you of better policies if they become available. It's never too early to be thinking about how your assets will be distributed in the event of a tragedy. At the end of the day, it's not about your net worth. It's about taking care of the people you love. Thank you.
Thank you so much, Jen. That was a really informative presentation. For those of you who attended, thank you for being with us today. I will make sure that any questions that come to me get passed along to Jen for follow-up, and we will post a recording of this webinar on our website in the very near future. So thanks again, and enjoy the rest of your day.
Take care.